Thank you all for attending today's webinar, the Reform Readiness for NATSIFAC Providers. My name is Shonella Tatipata, the Assistant Secretary for First Nations Aged Care Branch from the Department of Health and Aged Care. I'll begin by acknowledging the traditional custodians of the lands on which we are virtually meeting today. I am based in Canberra on the lands of the Ngunnawal people, and I acknowledge and pay respect to their continuing culture and the contribution they make to the life of this city and this region. I also extend that acknowledgement and respect to other families with a connection to this region and any other Aboriginal or Torres Strait Islander people who are here with us today. Just some virtual housekeeping in the webinar today. There will be a Q&A session at the end of the webinar. There is no option for attendees to turn on their video or microphone, but please feel free to submit questions in the Q&A function. You may need to click on the Q&A icon at the top of your screen to activate the function before submitting any questions. We will attempt to respond to as many questions as possible. However, we ask that the NATSIFAC providers be given the opportunity to provide questions in the first instance. All questions and answers, including ones that we may not get to today, will be published in an FAQ document on our website. Any questions submitted during the registration process have also been considered for today's Q&A session. We do sometimes receive questions that are unclear or not directly relevant to this webinar. If we are unable to answer a question during the session, we will follow up with the relevant areas in the department and respond through an FAQ document. Webinar slides are now available on our website. This session is being recorded and will be published on our website in the coming days. Our aim today for this webinar is to provide the NATSIFAC providers with an understanding of how the new Aged Care Act will impact them. We appreciate the fact that this is the first time that the NATSIFAC program will be regulated under the Aged Care Act, and we recognise it's a major transition for many of our providers. It means that the majority of your obligations, conditions and reporting requirements will be outlined in the Act rather than in your funding agreements. It is critical that NATSIFAC providers understand what these changes mean, and it's important to note that while there are regulatory changes in practical terms, the NATSIFAC program remains unchanged. It is our intent we are retaining the flexibility within the funding and service delivery model, and providers will be able to continue to deliver flexible, culturally safe care to meet the individual needs of older Aboriginal and Torres Strait Islander people and local communities. Our department will also be engaging an organisation to provide tailored support to NATSIFAC providers over a period of 2 years. This support will ensure that providers have capability and capacity to meet the requirements of the new regulations. It will be similar in many respects to the project that was run when the Single Quality Framework Aged Care Standards was introduced in 2019. Our team of presenters are critical partners in our aged care work, and joining me today to present is Robert Day, the Assistant Secretary of the Harmonisation and Regulatory Strategy Branch, whom many of you will already know from previous webinars. And he's here to provide more information about the new aged care regulatory model. Imran, who is the Director of the Worker Regulations section, to speak about the new worker screening requirements. James Cole, Director of Aged Care Assessments Policy, to discuss the single assessment system. And also James Chen, our Director, joining us from the Independent Health and Aged Care Pricing Authority, to share more information on the upcoming NATSIFAC costing model study. Before we go to the presenters, just a reminder to remember you can add your questions through the presentations, throughout the presentations in the Q&A function on the side panel. If you like someone's comment, you can click the thumbs up icon. To show support or agreement with a question or comment, you can vote by clicking the up arrow. This way we can see if there's anything we need to answer as a high priority in one of the 2 Q&A sessions that will be following some of these presentations today. So with that said, I'd like to invite the first speaker, Robert Day, to share information on the new regulatory model. Thank you.
Thanks so much, Shonella. Hi, everyone. It's really good to be part of the conversation today. As Shonella's already said, I look after a team in the department that's called Harmonisation and Regulatory Strategy. And in the context of the discussion that we're having today and the new Aged Care Act, that really means that the legal framework that's set up in the new Aged Care Act to structure the obligations of all aged care providers, including NATSIFAC providers. And it's also about the system for bringing providers into the aged care system. So today, that's what I'm going to try and talk you through, what that structure is, how the obligations of NATSIFAC providers will look under the new Act, and hopefully as I'm talking through, sorry, excuse me while I dance and make the lights go back on. There we go. I've been sitting still for too long, apparently. I'll talk you through the way the obligations for NATSIFAC providers will be structured under the new Act, and hopefully as I do that, you'll start to get a feel that there's a lot of similarity, even though the location of the obligations will move from the grant funding agreement to the Act. There's a lot of similarity between those 2 sets of obligations. I'm also then going to talk you through what we call the deeming process, the process that we will take you through to translate your organisation from your current status to the status of registered provider under the new Act. And then I'll talk through briefly at the end how renewal of registration will work after the new Act commences, because that'll be a process that all of your organisations will go through at some point, usually in the next 3 years after the Act starts. So as a reminder, the new regulatory model for aged care is a part of the new Act, and it's a direct response to some findings from the Aged Care Royal Commission. And that Royal Commission told us a couple of things about the way we regulate aged care. It told us that we needed to change the system to better protect older people. And it particularly told us that we weren't doing enough with our processes for bringing providers into the Act to really provide those protections in the best possible way. The Royal Commission, though, also highlighted for us the importance of, or that one of the greatest protections for older people from harm is a system that encourages providers to be excellent in the care they deliver and encourages a process of continuous learning and improvement. And so as we've designed the new regulatory model, which is going to apply to all providers of aged care, we've really tried to strike that balance between protecting older people from harm, but making sure that the obligations we set out for providers are proportionate, and they've got that way of incentivising excellence, that way of incentivising and supporting a culture of continuous learning and improvement. And so the reg model is based around these 4 key pillars. As you would expect, given that the new Aged Care Act is rights-based, we want the new regulatory model to be rights-based and focused on the rights of the elders and the older people that you are caring for in your services. We want the regulatory model to be person-centred, and so we take the needs of the individual, the views of the individual and their community as the cornerstone for how we respond to anything that might not be going right, but also how we judge quality and safety of care. We want the system to be risk-based, which means that we're looking at where there might be risks and responding to that and being proportionate to the level of risk. And as I've already said, we want to have a focus on continuous learning and continuous improvement in the way we regulate and in the services that elders and older people receive. As Shonella has already said, the Act will be the first time that NATSIFAC providers come under the Aged Care Act. And one of the key concepts in the Act is that every aged care provider is a registered provider. And so it doesn't matter whether you're a NATSIFAC provider or a CHSP provider or a residential aged care provider, every provider is considered a registered provider. And this slide gives you a little bit of a sense of how we're mapping all of those current programs to registered provider status under the new Act. Significantly for the NATSIFAC program, the program was going to continue to be a grant-funded program, and that means in the language of the Act, NATSIFAC will be one of the specialist aged care programs. And so you'll be registered, you'll have some legal obligations as a registered provider, but your funding will continue to come through to you through a grant. And that, I think, really importantly means because the funding is coming through you to that grant, you'll continue to have the flexibility to deliver services in line with the individual and the community needs of the elders and the people that you are caring for. In terms of some of the key changes that are coming in the regulatory model, one of them is the concept of universal provider registration. And so that means both that every provider is registered, but it also means that where you're part of a larger organisation that's delivering multiple types of aged care service, you'll have just one registration that covers all of those services. The role of the Aged Care Quality and Safety Commission will change. So you will already be familiar with the Commission undertaking quality reviews of the services you deliver through the NATSIFAC program. And that will just, that role will evolve slightly. So the Commission will also now have a role in registering new NATSIFAC providers into the system and applications for renewal of registration as well. And then the new Act brings some more powers for the Commission, not just for NATSIFAC, but for all aged care providers, to increase the range of options the Commission has in terms of monitoring the quality of care that's delivered and responding to any issues that might occur. I think one of the really important questions in the way we've designed the new regulatory model, and particularly how we balance both having that single provider registration and having all the aged care programs, including NATSIFAC, under the Act, is how do we frame the obligations in a way that is proportionate to the types of services that you're offering, to the context in which you're offering those services, and doesn't become overly burdensome on any provider, while also providing the protections that older people and elders rightly deserve. And the way that we're doing that is by creating two ways. One is a series of registration categories that group together services of a similar type with similar risk that's inherent to them. And that lets us frame the obligations and the requirements of providers around those risks. But also all of the obligations under the Act are set to be applied to kinds of providers. And so that means there'll be some obligations that will apply to all providers, some that will apply based on the registration categories that you operate in, and others that might apply based on the type of organisation that you are. And so there'll be some obligations that don't apply to specialist aged care providers, including NATSIFAC providers, for example. The slide that you can see on the screen here is a really nice summary, I think, of the way that we are starting to use those registration categories for a proportionate approach to regulation. And so you'll see that there are some types of service where the aged care quality standards won't apply, but that as you move through those service types, those registration categories, and you get down towards residential aged care at the bottom, there's a greater level of responsibility that goes with those services because it is a more intensive service type. There's a greater level of risk inherent in that. And yes, so I think it's probably the other point to make here is in terms of NATSIFAC providers, as we move you into the new Act, and I'll talk about the deeming process in a couple of slides' time, we will determine which of these registration categories apply to you based on the service types that are already covered in your funding agreement. Where you've got a residential aged care component, you'll be registered in category 6. Where you've got home and community services, you may be registered in a combination of categories 1, 2, 3, 4, or 5, and possibly you'll be registered in all 6 categories if you're offering services that cover all of those categories. Let's move on to the next slide, please, Alison. And so this slide notes that there are also some obligations that are going to apply to all types of registered providers, regardless of the registration category that you're operating in or the services that you need. A couple of these will be new for NATSIFAC providers. So one that is new for all forms of aged care provider is the Statement of Rights. That's the sort of the foundational piece of the new Aged Care Act. And there's an obligation for all aged care providers to understand those rights and to have systems in place to ensure those rights are respected in the way services are delivered. The Code of Conduct for aged care workers and providers will also be a requirement that will apply to NATSIFAC providers for the first time, although the underlying expectations, both in that Code of Conduct and in the Statement of Rights that are around respecting the individual and providing safe care, they'll be really familiar to you in the way you're offering services already. And so I'm hoping that your experience of that will not be a major change. Some of the other obligations that will apply to all aged care providers, one is around worker screening arrangements. I know you already have some police check arrangements in place, and Imran's going to follow me and talk to you about that in some more detail. Consistent with your obligations under your NATSIFAC agreements at the moment, all providers will need to have incident management systems and complaint systems in place. And all providers will need to meet the financial and prudential standards that are set for them by the Quality and Safety Commission. And I know there's an active piece of policy work at the moment around exactly what those conditions look like and how they apply to NATSIFAC providers. One of the things that we are going to do, or I guess two things to note, there will continue to be a NATSIFAC program manual, and that will still be the single place you can go to see all of your obligations in one place. My team and I are also working through or developing in consultation with Shonella's team a Regulatory Model 101 booklet specifically for NATSIFAC providers, so you can see all of this information in one place and know what to prepare for. We might actually skip ahead 2 slides at this point, Alison, to the one with the arrow, please. Thank you. And so I think I've teased you a little bit already with the fact that we'll go through a process called deeming to translate all providers, including NATSIFAC providers, from whatever their current status is to the status of registered provider under the new Act. And that will be a legal process that we go through. And for NATSIFAC providers, it will be about, through a legal instrument, creating your organisation as a registered provider under the Act for the first time, and assigning you to the registration categories that reflect the services that you're currently offering. That will be an automatic process. It will happen by operation of law. You won't need to fill in any forms. You won't need to pay any application fees. It will happen for you automatically, but we are going through a few steps along the way to make sure that we get that process as right as we can and as accurate as we can. We did go through a little bit of a process late last year, which we called the deeming validation process, and that's where we undertook a survey to make sure that we had accurate information about providers, and it let us test some of the computer algorithms that we'll use to manage the change. The next step is coming up in a couple of weeks in April, and it's called the provider registration preview. And that's where we will come out to you with a PDF document that is, as it says, a preview of what your deemed status will look like under the new Act. And it's a chance for you to see that, to start to prepare for it, but also to let us know if there's anything that we haven't understood correctly and to make those changes. So as I said, that document will come to you as a PDF. It'll come to you as an email, from the email address that you can see on the slide there, noreply@communications.health.gov.au. If the information that we show you in that preview is correct, you don't need to do anything. It means that the information on our database is accurate. It means our computer algorithm's working properly, and that will tell you how you're going to be set up under the new Aged Care Act. If there is something that's not quite right, then it's really important that you get in touch with the NATSIFAC team in the department, let them know what's not quite right, and we can change that. And there'll also be an email address in my team that you can contact if you've got any questions about that process, or if there's anything that's not making sense. So that process will open in early April, and we need to know if there's anything that's not quite right about what we're showing you in that preview by the 1st of June, so that we can make the changes and be ready for 1 July. And as this slide says, what you can do to help prepare, and particularly once you see that preview, is to let us know if there's anything that's not right. Sing out either to natsifac@health.gov.au, or my team's email, which will pop up on a later slide. Let us know if there's any questions. Let us know if there's anything that doesn't look right. And finally, let's talk a little bit about what the process will be for renewing registration after the 1st of July. So that status of registered provider for all aged care providers is going to be a time-limited registration. Typically, it'll be a 3-year period, but the Quality and Safety Commission will be able to offer both a shorter or a longer period based on the assessment they have of how an organisation is going in the system. And it's basically a way of touching base every few years to make sure that all the aged care providers that we've got in the system are the right organisations to be there, and that they are delivering safe and quality care, that they are embracing that opportunity for continuous improvement. When we send you that provider preview in April, it will include an indicative date for the initial expiry of your registration. So it'll give you a sense of when you're first going to need to go through this process for registration. There will be an application form that the Quality and Safety Commission will publish. That will be the way that you apply for registration. They will actually contact you and say, hey, it's time to apply for renewal. Here's the information. There will usually be fees associated with that renewal. But as is the case at the moment, there are going to be some generous waiver provisions for those fees, both for providers operating in rural and remote areas, and also a new waiver criteria for Aboriginal community-controlled organisations specifically as well. This is my final slide. I know that's been a lot, but if you want any more information, there's a web link there about the regulatory model you can go and have a look at. There's the email for my team that I promised that you're very welcome to get in touch with, and we'll come out to you all directly with that 101 booklet on the new regulatory model to give you a bit more background information. Thanks for your time and attention. Thanks, Shonella.
Thank you, Rob. I'd like to now invite the next speaker, Imran Church, who'll be speaking about aged care worker screening. Thanks, Imran.
Yes, and thank you, Shonella. Thanks, everybody, for being here, for the opportunity to talk to you all about new worker screening requirements for the aged care sector. So, as Shonella said at the beginning of this webinar, my name is Imran Church, and I work as a director in the worker regulations section of the department. So today for you, I'm going to be providing an overview of the new and coming aged care worker screening requirements, and I'm going to focus particularly on the requirements that will apply from the 1st of July 2025. I'll also give an overview briefly of the transition pathway towards future worker screening requirements to come in subsequent years. So to provide a bit of background, one of the recommendations of the Royal Commission into Aged Care Quality and Safety concerned criminal history screening requirements. While there are existing criminal history screening requirements in place for approved providers as well as NATSIFAC providers, we're working currently with states and territories on introducing a more comprehensive national worker screening process. Worker screening is an important safeguard measure to protect individuals receiving funded aged care services. As I'm sure you're aware, there are also criminal screening requirements that apply when working with other vulnerable members of the community, for example, children and NDIS participants. So the process that we're working through with the states and territories is to expand NDIS, National Disability Insurance Scheme worker screening, to the aged care sector. So that's what I'm going to be talking about today in this presentation. So onto the next slide, please, Alison. The worker screening rules that will commence when the new Aged Care Act commences, so that's 1 July 2025. The draft rules for worker screening were published under what was known as Stage 3 of the Aged Care Rules consultation. That consultation period has just recently, last week, closed as of 13 March 2025. So the next steps are that we will be considering the feedback received from that consultation process to inform what the finalised rules will look like. The draft worker screening rules set out the requirements that will apply on 1 July 2025, as well as the future requirements. And one thing we did do was to publish 2 fact sheets on our website. And the intention of those was to outline in hopefully plain language what the requirements are from 1 July 2025 from the provider perspective and also from the worker and responsible person's perspective. So yes, as I mentioned, we are currently in the process of considering feedback from that consultation process and we'll work towards finalising the rules from there. So moving on to the content of the draft aged care rules sent out. So the draft aged care rules set out the worker screening requirements that will apply from 1 July 2025, as well as the future arrangements. Important to note that this will be done in a phased approach, and the rules refer to these phases as 3 stages. First is an interim period, which is when the new Aged Care Act and the rules commence. That period is intended to maintain the status quo for the majority of providers and workers up until an agreement is finalised with states and territories for the expansion of NDIS worker screening to the aged care sector. So during that interim period, aged care workers and responsible persons will require a police certificate or an NDIS check, and that's what currently applies now. Following that, there will be a transitional period, and that will be when states and territories are ready to commence worker screening. So at that point in time, my apologies. At that point in time, an aged care worker or responsible person will be able to continue to rely on their police certificate until it expires. So that's a transitional measure. We do want to avoid all aged care workers and responsible persons having to apply for a new check on day 1 of the new arrangements, as we would expect that would cause backlogs and wait times for the worker screening unit that conducts the check. And then finally, we have the full implementation period, and that will be a set time frame from when the transitional period commences. Now, at that point, that is the time when police certificates will no longer be accepted for an aged care worker in a risk-assessed role or for a responsible person. So now I'm going to focus on the interim period, as I foreshadowed at the start of my presentation. So that's the requirements that will apply from 1 July 2025. If we can move on, please, Alison. So from 1 July 2025, the requirements are that each aged care worker and responsible person will require a police certificate or an NDIS check. If the person's been living overseas after turning 16, they may also need to provide a statutory declaration. So those requirements are what currently apply as part of the NATSIFAC program manual. So hopefully that should be familiar to you and your existing processes. A couple of stipulations. The police certificate must not be older than 3 years, and it must not record certain offences, and I will come on to those very shortly. And again, that's consistent with what's currently required as part of the NATSIFAC manual. The registered provider must keep a record of the person's police certificate or NDIS check, or if relevant, a statutory declaration made by the person. And if an aged care worker or responsible person commits one of the listed offences, then the registered provider must not allow that person to continue to work in the delivery of a funded aged care service. So worker screening from 1 July 2025. I'll now outline the offences that were listed in the draft aged care worker screening rules, which will be applicable to NATSIFAC providers. So these offences are those that are currently listed in the NATSIFAC manual, so they should be familiar. The offences are different to what applies to other registered providers. The reason is our intent is to reduce disruption to the aged care workforce from 1 July 2025 and to provide a transitioned process to the new worker screening checks. We understand there can be difficulties in interpreting offences listed on a police certificate. And this is also more complex as offences may be described differently across jurisdictions. So one of the benefits of expanding NDIS worker screening to the aged care sector is that it will actually be worker screening units in states and territories that make the decision on a person working in a risk assessed role and their clearance decision, rather than the onus and workload being on the registered provider. So I've highlighted the requirements coming in as of 1 July 2025 and what providers will need to do in readiness for that time. I'm just going to briefly outline the future worker screening requirements. So once the new national screening process commences, each registered provider will need to make sure that any responsible person or aged care worker they have in a risk assessed role has one of the following. Either one, an NDIS or aged care worker screening clearance. And once they've got that, a person will be able to work in either sector. That is, they only need to apply once, and this will be automatically recognised across both sectors. Second option is APRA registration. Now, for this one, it is important to note that APRA registration will only be recognised for aged care purposes. So what that means is if a worker is also delivering supports and services to NDIS participants, they will still need to comply with NDIS worker screening requirements. And then the third option for the transitional period is a police certificate, which was issued prior to the commencement of that transitional period. So that's a transitional member only, and the purpose of this is to manage workforce disruption and to as I mentioned before, manage that flow of workers applying for new worker screening checks and avoiding creating backlogs and delays in worker screening units. I will mention that one thing we are doing, as well as the rules, is working on ICT systems to support the new obligations, so that it'll be as easy as possible for registered providers to keep track of clearances for the workforce. And we're working to make sure that those ICT systems are ready to go live when states and territories are ready to commence worker screening. So I wanted to outline some of the benefits of the future worker screening requirements. The expansion of NDIS worker screening is an important reform measure for the aged care sector. So the government's been working with the states and territories on this expansion closely. The expansion is dependent on the commencement of, one, the new Aged Care Act, but also state and territory legislation. And that's why the new worker screening requirements across the board won't commence before 2026. So the new worker screening process will improve safeguards for individuals accessing funded aged care services by providing increased protections. And it'll be as I mentioned before, it's the state and territory worker screening unit who conduct the assessment of the person's criminal history background check, which is something they've got a great deal of experience doing. So it will be them that issue decisions on granting workers or responsible persons a clearance or making an exclusion decision. If a person's granted a clearance, it's valid for a 5-year period, although, of course, any new criminal charges would need to be considered by the worker screening unit. I mentioned before that workers will be able to operate across both the aged care and the NDIS sectors, and also they'll be able to work across any jurisdiction. So, for example, if a person obtains a screening check in one state, but then subsequently moves interstate to another, they can bring their clearance with them. Now, I understand some of you already operate in the NDIS sector, so you may well be very familiar with the worker screening process. So this is my final slide coming up. So we understand there are concerns about the impacts of the expansion of NDIS worker screening to the aged care sector. So we are working very closely with states and territories, and we will work with the sector to develop targeted engagement, communications products, guidance material, training to assist providers and workers to understand the new worker screening processes. Once that agreement is finalised with states and territories, we will be supporting the sector in moving towards the new worker screening requirements. So there will be a lot of further information coming your way. But in the meantime, I hope you found this overview, and particularly on the 1 July requirements, to be of assistance in preparing for 1 July 2025. Thank you very much.
Thanks, Imran. So, sorry, I'll look over here. So that's our first two presentations. Just wanted to pause there and consider some questions on the basis of what we've shared, but also there were some also that were pre-submitted that I might actually start with Imran. I know that there were a couple of questions that we received around worker screening. Did you want to address those first, and then I'll have a look at what else has come through?
Yeah, very happy to start with those, Shonella, thank you. What I might do is, there were some pre-submitted questions, so we've developed some, we've looked into those in advance. So what I might do is, for benefit of people on the call, I'll read out the question asked and then provide the responses we've come up with. So the first question was around different treatment of some criminal offences between different provider types. So in particular, the Commonwealth Home Support Program and the NATSIFAC program, and also residential care or supported home workers. So all government-funded aged care providers are subject to worker screening requirements. However, as it stands currently, these requirements differ, and in some cases quite significantly, depending on whether the provider is governed by legislation, that is the current Aged Care Act 1997 and the accountability principles. Those apply in the case of supported home workers, for example, or through a grant agreement, which is the case for NATSIFAC and Commonwealth Home Support Program or CHSP providers. So what that has meant is that historically that's led to inconsistencies between the different types of providers. So the reason for maintaining different offences for the different providers for the interim period as of 1 July is just that it is a transition period. Well, we're calling it an interim period, but the intention is to ensure a gradual transition towards future arrangements and to avoid or minimise the risk of workforce disruption. So, I mean, the positive news from a NATSIFAC perspective is that from 1 July 2025, the only providers in the sector who will see changing offence requirements are providers under the CHSP program. And what we're doing is that the offences applying to CHSP providers, we're going to align those with the NATSIFAC offences. The reason that's the group of providers that will face some different requirements are that CHSP providers under their manual have previously operated without having offences listed in there. So that's why, whereas NATSIFAC, there is already a list of offences, so we were content to leave those as were, but bring CHSP up to the NATSIFAC level. So, as I mentioned, the current arrangements for NATSIFAC providers, as well as supported home providers, will remain the same throughout the interim period, up until states and territories are ready to commence worker screening. As I've mentioned, that's still some time off. It won't be until some way into 2026, once the intergovernmental agreement is settled and finalised. In the future, once we do have the national scheme in place, the new national worker screening checks will apply to all registered providers and will be in a place of consistency across the sector. As I've mentioned, our department will work with providers, and we're in the process of developing a suite of communication and change products to help ensure as smooth a pathway as possible towards the future arrangements. It'll include tailored sector and stakeholder engagement, readiness information, guidance, and training materials. So that was one of the two pre-submitted questions we had on worker screening. Shonella and Rob, are you happy for me to address the second one now, or hand back to one of you first?
I might jump in if that's okay. I've just noticed there's some other questions in there, but I can see the team of in the background have been answering some questions as we've sort of been going along. But there's a question in there that my question to the panel is most aged care is not culturally appropriate, as segregation and isolation are two big issues for Aboriginal people. This kind of marries alongside one that was pre-submitted around considering the cultural loading, cultural brokerage and recognition of all Aboriginal and Torres Strait Islander peoples providing flexible aged care services. How will we measure and monitor accountability of culturally appropriate service quality and quantity at this interface of flexible aged care provision and culture? So I'll try and answer both, I guess, with considerations of some of the things that have been shared and will be shared in some of the presentations to come, but also these are considerations that the department and the government have been really focused on as part of these aged care reforms and in response to the Royal Commission in terms of that call out for cultural safety and what does it look like in practice, and being person-centered and thinking about the shift, in terms of what Rob was sharing in his presentation around a focus being rights-based, and the structure around that, being really considered in terms of the different stakeholders involved in the governance as well as the service delivery and the compliance and regulatory sort of environment as well. So in terms of what Rob shared earlier, he talked about the Aged Care Quality and Safety Commission's role and the work that's being undertaken to implement strengthened aged care quality standards as well. And that has been really focused on enhancing and clarifying requirements for what person-centered and diversity, and a greater focus on cultural safety. So the 8 standards that were mentioned in that first presentation does require providers to deliver culturally safe care and support to individuals to cultivate relationships and social connections, and it includes supporting for individuals, both staff and clients, like our elders who identify as Aboriginal and Torres Strait Islander, to engage in meaningful and active partnerships, to stay connected with persons, stay connected with community, culture and country. So from that perspective, there's a real opportunity here through the aged care reforms for providers to communicate what that actually looks like in practice, and to be able to share their story as part of that. But from a care recipient lens, like there are things built into the system now where there's, I guess, the levers to be able to require that of the system as well. So yeah, I hope that answers those 2 questions. I know I sort of tried to tackle it together, but it's going to be an ongoing dialogue, I guess, with the sector, and to sort of as the work is undertaken in this journey to bring NATSIFAC providers under the Act and what it means in practice. And but yeah, sorry, that's probably a bit long-winded, but I am mindful of time. Rob, did you have anything? I can't see any questions sort of sticking out for your space, but
I think there's one that's just popped up in the last couple of moments, Shonella,
okay,
around incident management and risk management.
okay,
In terms of incident management, my understanding is both having an incident management system in place and being able to report through the serious incident response scheme is already an obligation through the NATSIFAC program manual. And so the incident management obligation that will apply under the new Act should be the same as that, or at least very, very similar to that. There's not a standalone new obligation around risk management that I'm aware of. I think there is, in the quality standards both now and the strengthened version, some references to being able to respond to risks for the people that you're caring for. I think in my presentation, when I used that language around risk-based and risk proportionate, that was actually about decisions that we're trying to make in government in terms of what's the right set of obligations to put in place for aged care providers, and it's about the approach the Quality and Safety Commission will take. So whenever they're engaging with you about something that hasn't quite gone right, they'll be asking themselves, what's the risk of harm to an older person in this situation, and what's the approach of the provider or organisation in responding to that? And if you're on top of it and you're seeking to take action to both address the thing that didn't quite go right and to fix it for the future, then they'll take a fairly positive, supportive approach to regulation. But if they're talking to an aged care provider who, is resistant, doesn't want to have a conversation with them, doesn't appear to have any genuine interest in improving the situation, that's when they'll start to use their serious compliance power. So the risk bit, I think, in my presentation was more about the way that we in the department and in the Quality and Safety Commission will use the tools under the new Act, rather than an obligation on NATSIFAC providers specifically.
thanks, Rob. Okay, well, thank you both. I might move on to the next speaker, mindful of time, and noting that we'll probably have another opportunity to answer questions. So I'd like to now invite our next speaker, James Cole, who'll be talking about the single assessment system update.
Thanks, Shonella, and thanks everyone for having me. So I'm James Cole. I'm the Acting Director for the Assessment Policy section in the Single Assessment System branch, just under Julia Atkinson, my Assistant Secretary. I'm joining you today from Wurundjeri country here in Victoria. So in terms of today's or my short presentation on the single assessment system, I'm first just going to take you through what the system is, because essentially it's going to look very similar in a few months' time under the Aged Care Act 2024. So I'll talk a little bit about what the system is now, some of the changes that we've seen in the last few months, and then I'm going to, I guess, contextualise the single assessment system with NATSIFAC providers from 1 July, and like, what does it mean for you from that big date? So in terms of the single assessment system, as I sort of mentioned, it's a reform that's we've had the sort of pleasure of implementing from 1 July last year, which sort of commenced with the first component. So essentially there are three components. The integrated assessment tool, which commenced on 1 July 24 last year, is the assessment tool that aged care needs assessors use to determine aged care needs. So that tool features a host of questions across various domains: medical questions, physical, function, social. So these questions help determine the level of care that the person being assessed requires. The IAT, the Integrated Assessment Tool, the IAT uses the Kimberley Indigenous Cognitive Assessment and the Good Spirit, Good Life Guide for Aboriginal and Torres Strait Islander people with cognition issues, so that they're validated the most acceptable and reliable instruments for assessing the needs of Aboriginal and Torres Strait Islander people. We also have an offline form. So I did mention, so the IAT is an online form, but we have an offline form as well, which we use if it's more appropriate to do so. And then the assessor can go back to the office and upload the data that way to create a digital record. So that's the IAT. That's been in place since 1 July 24. And look, from all accounts, it's going along reasonably well. The single assessment system workforce, which I'll talk to in a little bit more detail in a couple of slides' time, that commenced on the 9th of December last year. And then the third component is the introduction of First Nations assessment organisations to provide a culturally safe pathway for older Aboriginal and Torres Strait Islander people when getting an assessment. So in terms of what's prompted the single assessment system, it is, of course, the Aged Care Royal Commission, which explored issues relating to aged care assessment, and it's issued those 2 recommendations on the screen there, which I'll just let you have a little look at. So if we want to go to the next slide, essentially, the idea of the single assessment system is to make it easier for older people to access aged care and adapt services as their needs change. The key elements of the single assessment system are creating a single assessment pathway for older people, supporting older people to not have to repeat their story multiple times, ensuring access to assessments in regional, remote and rural areas, and with the introduction of more assessment organisations, hopefully the goal of reducing wait times to access an aged care assessment for older people. So in terms of the single assessment system workforce, as you might know, prior to 9 December, we had regional assessment service workforces, so the RAS workforce. They used to do home support assessments, which would recommend CHSP, while we had an aged care assessment teams, so ACATs. These were sort of state and territory government teams, and they would do comprehensive assessments for HCP, flexible aged care programs, residential respite, and entry into residential care. Separate to this, we have the ANAC workforce, and the acronym is just there on the screen. See, the ANAC workforce determined funding classifications for those in residential care. So the single assessment system workforce, launched at 9 December last year, brings these workforces together, which does help create that single pathway. So unlike before, where we had state and territories doing ACAT assessments and non-government organisations doing RAS or ANAC assessments, we have a mix of for-profit, not-for-profit and state and territory governments delivering all of these assessment types. So the hope is that when someone arrives at an assessment organisation, there is a process which we describe as triage, where the person, where the triage person essentially determines whether they need a home support or a comprehensive assessment, and then assign that person to the right staff member with the right training and skills to do that assessment, versus rocking up to this assessment organisation only to be told, oh no, you're complex, you need to go to another assessment organisation entirely. That is hopefully a pathway that we've closed down through this single assessment system reform. So in terms of how we got there, we had a tender process last year, and we've had 17 organisations were awarded contracts to deliver the single assessment system. This is in addition to the state and territory governments who retain an important role in delivering assessments. So just the thing to note is there are at least 2 organisations operating in any one of the 22 service areas displayed on the slide there across Australia. I don't think I have the ability to enter into the chat a useful tool, so I'll make sure when we send out some comms that we can include this link. It's a really good one to find an assessment organisation in your service area. So if you Google find an aged care assessment organisation, hopefully the first result you get will be a link to our department's website, to a very useful website that you enter in your area, and it will tell you which assessment organisations are operating in your service area. So if we can move to the next slide, in terms of what this looks like for NATSIFAC providers, particularly from 1 July, as you know, from that date, all aged care services become ACT-based services, not just the current home care package and residential care packages. So this means anyone in receipt of NATSIFAC or CHSP aged care services will require an aged care needs assessment under the Aged Care Act 2024. So I understand that currently NATSIFAC providers provide an assessment to ascertain someone's needs when they present to your service. This won't change from 1 July 25. You will still be the first port of call for many older people in remote communities, and under the alternate entry provisions of the Aged Care Act 2024, you will be able to undertake an initial assessment and begin to provide services. The key change at this point is that you need to ensure that the person you have assessed to receive services immediately, that they are formally registered for an aged care needs assessment. Not that they have a formal aged care needs assessment completed in that time, but that they are formally just registered to apply for an aged care needs assessment. So we expect that the older person will have up to 30 days to make this application. You can also make this on their behalf, either by phone or online. So once that assessment referral has been created, one of the assessment organisations operating in that service area I showed earlier will get in touch to undertake an aged care needs assessment. Importantly, the services can commence in the meantime while the older person is waiting that aged care needs assessment. In short, the aged care needs assessment won't hold up service provision for NATSIFAC providers. The assessment organisation will work with the NATSIFAC organisation that is already providing care to inform their aged care assessment. So a lot of the information that you've gathered will help the assessment and can be used to avoid older Aboriginal and Torres Strait Islander people having to tell their story multiple times. There'll be an opportunity to discuss whether an in-person assessment is appropriate. While face-to-face assessments are best practice, we understand that there may be logistical difficulties in doing so, or other sensitivities may exist that act as a barrier to an in-person assessment. Instead, a telehealth assessment might be appropriate with a NATSIFAC provider staff member present with the older person to undertake the assessment. Assessments are a respectful conversation and typically take place somewhere where the older person feels at ease. Assessors are trained and guided to be respectful of an older person's culture and experiences, and will try to make the assessment as comfortable as possible for them. At the conclusion of the assessment, the assessor will recommend funded aged care services. So from 1 July, in most instances, for your clients, the assessor will recommend the NATSIFAC program and tailor the support plan so it aligns with the types of services already being provided. So I hope that clarifies some of the questions you have on the dynamics of single assessment from 1 July 25 as it relates to you. We really do recognise the important role NATSIFAC providers play and how critical they are to informing the assessment and its outcomes, and our guidance to aged care needs assessors will emphasise that their assessment should be consultative and multidisciplinary in its approach, and draw on the knowledge and insights that you have to ensure the best outcome for the older person. For your clients, like I've sort of explained, the key change for them is that in addition to interaction with the NATSIFAC provider, there'll also be an interaction with an aged care assessor and elder care support team if they are in your area. Over time, as it gets rolled out, it might be a First Nations assessment organisation that does that assessment. For your clients, the key benefit of being assessed under the single assessment system is the flexibility it provides the client. There may be instances where your clients need to be away from their usual place of residence, for example, if travelling for extended periods on sorry business. The benefit of being assessed is having information about their care needs available to other assessment organisations who might be able to support them while they're away, minimising the need to retell their story and helping ensure they get continuity of services. And one of the other advantages of introducing the single assessment system pathway is we will be able to improve data collection and better understand service need, supporting business cases into the future. Thank you for having me for these 11 or so minutes. I would just say, I guess, over the next, in those first few weeks of 1 July, continue to keep in touch. No doubt you'll be in touch with Shonella. You don't need me to say that, but yeah, we'll really look forward to sort of working with you and hearing about what's working and what isn't working. Thanks.
Thanks, James. So we might move on to the next speaker, James Chen. I'll invite him now. He'll be sharing some information about the upcoming NATSIFAC costing study, and then we'll have another Q&A session after that. Thanks, James.
Shonella. Thanks, Shonella. So my name is James Chen. I'm the Director of Aged Care Costing here at the Independent Health and Aged Care Pricing Authority. So to start off, I thought I'd just go have a bit of a background about who IHACPA is. So IHACPA was established in 2012 as an independent government agency responsible for developing health and aged care pricing advice, as is described in the National Health Reform Act of 2011. So IHACPA's costing study, collecting costs allows IHACPA to understand really the resources required to deliver care across different settings and residents of different needs. So in 2023, IHACPA completed its first large-scale cost collection, and that was in the residential aged care space, which provided us data data collection specifications and methodologies to try and understand the resources that were required to deliver care in the aged care sector. In 2024, IHACPA commenced its 2024 residential aged care cost collection, and this will continue into the end of 2025. This is our next foray into understanding the cost of delivery into care in the residential aged care sector, and it looks at increasing our sample to understand the different variances that happen across different settings, and collection of really high quality data and representative data, including costs. The time of activity is really paramount to allowing IHACPA to provide up-to-date and evidence-based price advice to the Minister. So the data that we collect as part of our cost collections and costing studies is used to form the basis of future pricing, classification development that's work done through the agency. So I've spoken a bit about and I'm going to base a lot of this talk around what we've done in the residential aged care space, because that's something that we've provided a price on recently, but we definitely look into the other aspects of the aged care service as well. So costing is really important. So it really allows us to understand what it costs to provide care to a resident. So in our cost collections that we've done so far, we're basing our costs on resource utilization. So this could be in terms of how much time a staff member spends with a resident. It can be the type of staff, with certain professions costing more than other professions, or other products being utilized in the delivery of care for a resident. So costing is all about placing a cost that's based on how many resources a resident utilizes as part of their care. So from here, IHACPA can create data sets that show the differences between the resources and the costs required, and in different contexts, such as size or rurality, or the type of residence that a facility provides care for. And ultimately, one of IHACPA's really big aims is to produce a price advice that reflects the true cost of delivering care. So it's evidence-based, and we're transparent, and it's showing what the actual cost of delivering care is. So once we collect our costs, and this is what we've done in our residential aged care price advice for 24-25, this is a little flow diagram to explain at a really high level of how the data that we get turns into pricing. So once we have a data set, we prepare the data, and this involves looking at some trimming rules. So removing any data points that might be erroneous. So either ones that seem abnormally too high or too low. If we have data that's collected that isn't a representative of the entire cohort, the sample becomes scaled to ensure that each categorization of facility is represented fairly. Any costs that are deemed out of scope within the policy are removed, and this is determined through the policy levers. And if there are any mandatory care minute targets or any mandatory expenses that come through policy, these costs are scaled accordingly too. From here, we look at both the individual and the shared costs against any of the base care tariffs to ultimately get to a reference cost, a price weight. And finally, indexation. So we're collecting information from the past, but we have to provide a price that's in the future. So we index the prices, and we also apply adjustments for fair work, superannuation guarantees, and they're all adjusted for the upcoming financial year. So this is just a guide as to how, when we collect really accurate representative cost data, we're able to convert that into a price advice. And this is just a guide, and if there are any other policy levers that may be introduced, IHACPA will definitely take those into consideration as well. So more specifically in the NATSIFAC space, we want to understand what existing data there is. So we don't want to put any unnecessary burden on any providers. And we want to use the data that's currently being collected or whatever is currently available to really understand what's there and to look at what else we might need to collect. And we do intend to work with providers to understand the models of care, how care is delivered across the NATSIFAC space, and what costs are involved in the process. Depending on the data that's currently available to IHACPA, we'll work with the providers to try and understand if there's any additional requirements. Ultimately, we're looking to understand the cost of caring for clients within NATSIFAC providers and how busy you are. So the amount of activity, that lets us know if you are getting busier, then the price and the funding envelope should hopefully reflect that as well. And this will allow us in IHACPA to provide pricing advice that's representative and accurate to what it actually costs to deliver that care. So that's it from me. I had a very quick presentation. I'm happy to provide some contact details at the end to Shonella that can be distributed. We didn't have that in this presentation, but if there are any questions, I'm more than happy to take them. And I'll pass back to Shonella.
Thanks, James. So just adding to what James just shared there, I guess it's just to also provide the context that that review, you know, it also does extend to home care. We're just trying to understand, you know, what costs are involved in delivering NATSIFAC services, and it's an opportunity with James and his team, under IHACPA, you know, they'll be reaching out in the near future and working with NATSIFAC providers. And so it's just letting people know that this work is underway and sharing a little bit more information, noting that, again, there'll be more information as those conversations occur when they connect. So that leads us into the next opportunity for questions. Thank both James Chen and James Cole for their presentations, and just a few questions that are coming into the chat. I can see that. I just want to make sure that If there's any in particular that either
Yeah.
James can see.
I think there were a few there about grandfathering arrangements, or just, do I need to get an assessment now? And I'll do my best to answer these questions, but the reality is I just want to make sure I'm also giving you the right advice. So it might just be safest for everyone if I do take some of these questions on notice. But
Yeah.
in terms of the need to have an assessment done before 1 July, the advice I've got in front of me is essentially that people who have received services in the 12 months prior to the start of the new Act, so from 1 July last year up to 30 June, through a NATSIFAC service provider, they can continue to receive NATSIFAC services without needing an assessment, provided the older person consents to their data being collected for the process that will deem them across to the new Act. And Shonella, I'm not sure if you're familiar with that process, and if you want to talk to it, but so from what I don't know about that, the consent process, but that sounds like we don't need to worry about assessments having to be done before 1 July this year.
Yeah, there's work underway to as part of the transitional process in transitioning, because we're very committed to ensuring we're doing the right things when handling information and data as part of this transition work that's underway. So there is a process that the department is progressing at the moment with NATSIFAC providers to ensure that we can support that process, and we have consent in the appropriate way to be able to do that. And it's just covering the compliance requirements from the department's perspective, and ensuring we do the right things, by the providers and by the care recipients, and in line with our responsibilities. I am mindful that there are a few questions where we're probably going to have to go away and take some of these on notice and get some more advice, and making sure that you do have the right information in terms of the responses.
There are a couple of comments there around costs, and in terms of assessment organisations and how they are paid. They're paid on an assessment for a fee for service basis, so some of those logistical challenges that some of the comments are sort of going through or address, that is factored into the overall assessment price. So the assessment price of an assessment in, say, Northern Territory is going to be quite different to the assessment price, say, in where I am here in Melbourne. So to the extent that it's possible, we do factor in those costs. I think there was another question there around there's a threshold period in terms of a face-to-face assessment and telehealth. I'm happy for people to just, put in the questions a comment around a preference, like a face-to-face versus a telehealth. We do, while we have a high threshold for doing a face-to-face assessment in essentially non-remote or very remote areas, there's a lot more leniency for telehealth assessments in remote and very remote areas. I don't know whether that's preferred or not. It might be just really depends on the older person's situation and what they feel comfortable with. But we do provide a leniency there. There is, I think the comment was like, does it have to? Yeah, do you have to do a face-to-face after 12 months or something? There isn't anything prescriptive to that extent.
Yeah,
I think.
Sorry, James.
I think some of the questions are about capturing costs of specifically required for remote and very remote locations as well. Probably more to do with what we're capturing. I guess we want to understand all the costs that are involved in providing care to clients, whether if they are remote, very remote, including kind of straight costs and other expenses, and that will all be taken into consideration.
Yeah. Okay. I might invite the other presenters back if that's okay with the team, because and just see if there's any opportunity to answer, because I think I'm just mindful of time, but I saw there were some other questions that popped up after the other presenters had finished their Q&A. But unless either you're both James, so James C and you're both James C, so either James Chen or James Cole, like if you can't see any questions you could answer right now, I think I'm happy for the other presenters to come back on and see if we can answer any other questions. Is that okay with the team? Okay. Imran, I know there was a question, there was your second question that, if that's helpful, did you want to just address that now while Rob gets a chance to sort of have a look at what's in the chat?
Look, I'm happy to briefly, Shonella. I noticed there's also probably another couple of questions in the chat it relates to, a bit similar to what James was saying, James Cole was saying, sorry, want to make sure that we give attendees the correct and as complete an answer as we possibly can. It's in relation to forms of identification for the purposes of obtaining work screening checks. So I think it's one that we're best off taking on notice so that we can probably provide a fuller response than what I might be able to say today. What I will say is that, yeah, we're conscious that it is a challenge for remote and regional communities, or well, it can be a challenge to obtain a certificate or NDIS check due to identification requirements. We are planning, or in the process, I should say, of developing a range of solutions and engagement and education options to assist workers and providers in this regard. A range of communication products, and we're including those will be to understand the new screening process, navigate the system and submit applications. But I think it's best that I probably take it on notice and give a fuller response in our way around.
Yep. No, I can appreciate that, Imran. Yeah, I think I just really want to thank everyone for sharing your questions and the interest in our presentations today and taking the time to share those questions. I just want to assure everybody that we will be responding and providing considered responses in an FAQ after this session. So if we're not, it's not that we're not trying to be responsive now, we probably just need to have a bit of time to get the right information together to respond appropriately to your questions. But I'll just check in with each presenter that there isn't any asked questions that in there that you think you can answer. Otherwise, we might look to. Sorry.
I think there is one, Shonella, that I can take for you, which is Andrew's question about whether there's going to be a hotline that providers can call and talk to. Definitely in terms of the regulatory model, there is that address that I gave earlier and will be in the slides that everyone gets, but it's QADREG design at health.gov.au. That will come to my team. Feel free, as Andrew said, if it's easier to have a chat to say, I've got some questions, can someone please give me a call? But that way you'll get to everyone in my team rather than getting bottlenecked with one person. Equally, I know NATSIFAC providers are talking, Shonella, to your team on a fairly regular basis, and we can always organise to have a few of us jump on a call and talk through issues. So really happy to have a chat and talk through. There's a couple of different ways you can reach out to us if you'd like to have those one-on-one conversations.
Okay.
Shonella, I've just noticed a comment in the chat that I just thought I'd call out. So the comment is advice on assessment is incorrect and contradictory to what assessment service providers have been provided. CHSP clients accessing services without an assessment need to be assessed by 30 June. So yes, that is the case for unregistered CHSP clients. They do need to get an assessment prior to 30 June. But I think for reasons relating to the Constitution, I think for NATSIFAC clients, no, you do not need to get an assessment prior to 1 July 25.
Okay. Well, thanks, James. Well, I just want to say a sincere thank you to all the presenters, and again, really grateful for everyone online who took the time to join us today. We would really appreciate if you could complete a short survey just to help us improve our any future webinars we undertake. So please scan the QR code or follow the link we've posted in the Q&A, and this survey should only take about a minute to answer 4 short questions. But again, thank you. This concludes our presentation today, and please note that the FAQ in response to the questions that were shared today and a recording of this webinar will be available in the following days. Thank you very much for joining us today.